Your Honor, at this point, we'd like to make a motion for mistrial and make a proffer on it. First of all, at multiple points in the prosecution's closing, he made efforts to dehumanize the defendant. In fact, calling her a black widow, comparing her to a deadly spider, calling her a narcissist when there's been no evidence introduced to support that, no expert testimony, nothing of the nature. Furthermore, it's completely improper for the prosecution to comment on her demeanor while she sat at counsel table. That's a comment on her failure to testify. Asking the jury to take into consideration facial expressions, which in his opinion may or may not have happened. I don't know what he's basing that on. But it's improper, and it's our suggestion that is a comment on her failure to testify by revealing what her response to testimony was, is calling upon her to testify in this case. Furthermore, in the closing, there was wild speculation on what was in Kouri Richins' mind, completely made up by Mr. Bloodworth with no evidence whatsoever to support it. Also, Mr. Bloodworth wrongly told the jury that giving any illicit street drugs to Mr. Richins was sufficient to support aggravated murder. That, in fact, is not true. The only drug that would support aggravated murder would be fentanyl. What he said to the contrary is not consistent with the court's instructions, and we would ask that that be corrected with a curative instruction. That they should follow the court's instructions on what it takes. It would not be sufficient if she bought some other type of drug that did not cause his death. That's just not the law. Let's see, just a moment. I think that's it, Your Honor.
Mr. Bloodworth? Forgive me, I need a little bit more detail as I go through these.
Yeah.
Which of these do you want a curative instruction regarding, and which of these are you moving for a mistrial on?
Moving for mistrial on all of it, Your Honor. The curative instruction, I think, is required by the wrongful information that giving him any illicit street drug is sufficient to support aggravated murder. That's just not true. And that's super important, because if they do believe that, there is evidence to make a finding that there was oxycodone, and there was no oxycodone found in his body. So that can't support a conviction. So that's what I think requires the curative instruction. The rest of it, I don't know any way you can cure it, Your Honor.
The Utah Court of Appeals disagrees with you regarding the prosecutor's comments. A long line of cases talk about the potential prejudicial effect of an improper comment by a prosecutor only being able to be measured after the defense gives its closing and the state gives its rebuttal, and we consider any curative instructions. What's your alternative position there? I could, for example, instruct the jury that Mr. Bloodworth's observations of Ms. Richins' demeanor are not evidence, and they are to rely on their observations of Ms. Richins, if any, only.
I just don't even think that her demeanor is proper to rely upon, because she didn't testify.
Can be. I mean, she burst out in laughter during the showing of the decedent's body. I don't think it would be appropriate for me to tell the jury you can't possibly consider that.
I'm sorry, but I have no idea what you're talking about. I totally trust you, but I have no recollection of any laughter when his body was shown.
No, it was a hypothetical, Ms. Nestor.
Oh, thank goodness.
The bounds of your categorical statement that the jury can never consider the defendant's demeanor.
I'm sorry. I thought you were saying she did that, and I was just horrified.
Please stay focused.
But I am focused. I just misheard you. I mean, is what you're asking me is, do we want a curative instruction now? Do we want to wait until later? Is that what the court is asking?
Right.
Court's indulgence for just a moment. Okay, I think we do want it now, if we can get one now.
Let's hash that out for a second. What I proposed was an instruction that the jury may rely on their own observations, if any, of Ms. Richins' demeanor in trial, but they cannot rely on counsel's statements regarding what Ms. Richins' demeanor was. I want to be clear, there were no comments regarding her silence.
Well, I mean, it's our position that when you comment on how she looked while she remained silent at counsel table, that is a comment on her silence, in our estimation. But I agree that he didn't say anything specifically about silence. That instruction would be preferable to no instruction, I think.
Okay. And then the Black Widow comment was connected to comments that were made by Chelsea Barney, correct?
They came out of his mouth in closing.
And he specifically referenced Chelsea Barney's testimony. Is it your position that Chelsea Barney never used that phrase or words?
I don't recall her saying that, but it's been a long trial, and I would not want to make that I 1000% am sure, but I certainly don't recall that.
It was in the recorded phone call with Bryce Knudsen.
And then everybody is speculating as to defendant's state of mind. It's one of the factual issues that the jury will have to determine according to circumstantial evidence, because as we instruct them, there's no direct evidence of what's in her mind. Why was anything that Mr. Bloodworth said regarding the inferences that can be drawn regarding her state of mind inappropriate?
Because they were made up out of whole cloth with no evidence to back it up.
You're going to have to be more specific.
So he went to great lengths to fantasize about what she was thinking about when there's been no evidence to that. He could have certainly said, look, she could have been thinking this, she could have been thinking that. He didn't. He gave them what was in her mind, which is just based on things he made up in his own head, not based on evidence.
Why aren't they all based on his view of the evidence that came in at trial? Was there any references to evidence that did not come in?
Well, first of all, calling her a narcissist, I mean, that didn't come in. There was no testimony that she's ever been diagnosed to have a narcissistic personality disorder. There's no evidence at all about her mental condition. And then when he talked about her putting the reasoning why she picked certain days to get more attention, nothing about that has ever come into play, ever. I mean, that's just one of many. He went through lots of scenarios about what she was thinking as if it was a fact, and it wasn't. So, I mean, I think he can encourage the jury to use circumstantial evidence to try to reach their own conclusions, but he can't say this was in her mind when he doesn't know.
Okay. Anything else?
I think that's it, Your Honor.
Mr. Bloodworth, go ahead, sir.
Your Honor, were there any particular points that defense counsel raised that remain unresolved in the court's mind?
Any objection to the proposed instruction regarding the jury must rely on their own observations, if any, of defendant's demeanor, but cannot consider counsel's statements regarding her demeanor?
No objection.
Okay. And then the statement regarding giving any kind of illicit street drug is sufficient to show the murder count. Mm-hmm. Talk to me about that. I did catch that comment. They're not making that one up. Now, there was more, and in the total course of the state's initial opening, I think you made it clear that you were encouraging the jury to make specific findings beyond a reasonable doubt regarding each required element.
Mm-hmm.
There was that initial comment, though. I don't think an instruction regarding having trouble crafting a curative instruction that doesn't just give a theory of the case. What's your view of this?
Your Honor, I don't think anything needs to be cured. The state does not have to prove that the defendant intended to murder Eric Richins with fentanyl.
True.
The state only needs to prove that the defendant intended to murder him with the illicit street drugs that she purchased from Carmen Lauber.
And that they contained fentanyl. Yeah.
Well, I'm sorry, on the second element or the aggravator? Because there's a distinction there.
I think on both. She has to actually knowingly or intentionally cause the death for count one. So if she buys something that she thinks is OxyContin,
Correct.
and intends the giving of the OxyContin to kill him, and it turns out that what she got was blue M30s that had fentanyl and
Right.
it killed him, the difference between aggravated murder and murder is irrelevant. She has committed an aggravated murder. What the distinction I think that I acknowledge is that she doesn't have to intend to kill him with fentanyl. She has to intend to kill him with poison. Even if she thought she was getting one and got the other.
Correct.
As long as it worked,
Correct.
she committed the crime.
Correct. And I think that's what I said throughout.
I think that is the weight of the argument overall that you made.
If there's a particular sentence I said that is different than that, then I agree we should cure it. But I don't think I said anything different than that.
On this one, Ms. Nestor, I think the better course, rather than for the court to insert itself at this point, is to allow the rest of closing to play out, and we can readdress this issue at the end.
Okay.
I expect that this issue will get teased out in detail through Ms. Lewis's closing and the state's rebuttal. Give me a moment to collect my thoughts regarding the others. All right, thank you. Court will be in recess until... Oh, I'm sorry, go ahead.
I'm sorry, Your Honor, can I just maybe say one thing?
Yes, please.
The state did not refer to the defendant as a narcissist. The state said that that was a narcissistic injury.
Right, I got it. All right, we're back on the record in 231-500-139. Counsel for state and the defendant are present. The defendant is present as well. Counsel, this is what I propose. Let me give you a ruling regarding defendant's motion for mistrial. Then I propose I give the jury the curative instruction related to evidence of defendant's demeanor. Then I propose we take a lunch break, Ms. Lewis, so we're not interrupting your closing.
I agree with that.
Okay. Any objection, Mr. Bloodworth?
No objection, Your Honor.
All right. The issue before the court is a motion for mistrial and request for curative instruction in the alternative made by defendant on the record this morning. The motion for mistrial is based upon several comments made by Mr. Bloodworth in the state's initial opening that, in defendant's view, are so improper as to require a mistrial. The court will address defendant's arguments one at a time. First, the defendant argues that Mr. Bloodworth's reference to Chelsea Barney using the phrase Black Widow during a recorded telephone conversation that was played for the jury, though Chelsea Barney's comment was not admitted for its truth, improperly compares defendant to some kind of terrible insect. The court listened to the comment in real time during the state's opening. That is not a fair characterization. Rather, it was a rhetorical flourish by Mr. Bloodworth comparing comments by one witness or the defendant herself to her becoming a widow to Chelsea Barney, referring to or being referred to or considered as a black widow. It's not a reference to an insect, rather it's a reference to, in the court's view of Chelsea Barney's comment, a spouse that kills another spouse. There's nothing so improper or improper at all about that comparison, which has a factual foundation in Chelsea Barney's statements that were played for the jury as to support a request for mistrial or require any other relief. Moreover, the defendant requests a mistrial based upon, in defendant's view, Mr. Bloodworth characterizing Ms. Richins as a narcissist. Defendant argues that that is unsupported and improper expert testimony from counsel that has no basis in the evidence. The actual phrase used by Mr. Bloodworth was narcissistic injury in relation to Ms. Richins' hearing from Brooke Carrington when she testified that, in the state's view, defendants' appearances of wealth and success were not accurate. That is permissible line of advocacy during closing argument. It is not testifying in any way by Mr. Bloodworth. It is not otherwise prejudicial or unfairly prejudicial. With respect to Mr. Bloodworth's argument related to defendant's demeanor, the court determines that in an abundance of caution it is appropriate to instruct the jury that they may consider their observations of defendant's demeanor in the courtroom, if any, but they may not consider counsel's statements regarding counsel's observations of defendant's demeanor, as counsel's statements and counsel's observations are not evidence. Moreover, the court notes that Mr. Bloodworth did not comment on Ms. Richins' silence or in otherwise implicate her protected right to choose not to testify. Mr. Bloodworth's statements regarding what the state believes it has proven regarding defendant's state of mind at various points in time is permissible advocacy based upon evidence in the record, and defendant's counsel will have ample opportunity to try to persuade the jury to draw different inferences from that same evidence regarding defendant's state of mind. There's no basis for a mistrial there. And regarding any misstatement by Mr. Bloodworth in his initial comments regarding count 1 that may have created confusion as to whether the state needed to show that regardless of her intent to purchase, secure, or otherwise administer fentanyl, all the state needs to show is that Kouri Richins intended to purchase, secure, and administer poison, and that it happened to contain fentanyl. That was, on the one hand, borne out in detail through the rest of the state's initial closing, and the court expects will be borne out in detail through defendant's closing and the state's rebuttal. The court determines that no curative instruction is necessary on that point at this time. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. All right. Are we ready for the jury, Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay. Can we bring the jury in, please?